Welcome back to our discussion of USCIS site visits and the FDNS program. We left off discussing what you should make sure that you do during the actual site visit. Be sure that you are getting the name and contact information of the immigration officer so that you can get in contact with them later in case you are not able to provide all the information, or if you realize you mentioned something wrongly during the site visit. Be sure to accompany the officer throughout the entire visit. You don't want to allow them just to walk around wherever they want to and look into documents or anything like that. So just stay with them. At the beginning of the visit, if you are represented by an attorney, ask that the attorney be allowed to be there. They probably won't wait for the attorney to get there, but certainly try to immediately call the attorney and see if they can be available on the phone during the visit in case any problems or issues arise. If they're asking to take a look at your facility and it's a reasonable request, go ahead and comply. You don't want to be overly aggressive and make it look like you're trying to hide things. If during the questioning, if you're ever not 100% sure about an answer, it's better to state that you're not 100% sure and would prefer to get back to the officer as soon as possible rather than provide the wrong information. So don't guess at any of the answers. If you're not sure, just say, I need to take some time to look into that, and I'll provide the information as soon as I am able to. And again, that's why it's important to get all the proper contact information for the officer so that you can do that. And then during the visit, just keep in mind that anything negative that pops up during the visit can result in the petition being revoked. As I discussed before, these site visits usually occur after the application is already approved. But there's nothing saying that they can't later revoke that petition. So if they find, for example, that the proper wage was not paid, a couple months after the site visit, you can expect to see a notice of intent to revoke. You should be given an opportunity to respond to that. So if you have a valid reason why a certain wage wasn't paid, you can certainly argue that, but it's better to avoid those issues in the first place and make sure that all of your ducks are in a row, so to speak, so that you don't run into any problems. In a previous video presentation, I discussed the USCIS memorandum that came out on January 8th. This memo was regarding H-1B workers that are placed off-site at a third-party location, especially in the computer consulting industry. It seems that this memo, which talks about asking questions about how the H-1B employer is able to control the work of the H-1B worker when they are working at a client location off-site, it seems that the factors listed in this memo are being implemented during these site visits. So if you are not familiar with this memo, definitely read through it or take a look at our other video presentation. We did a 3-part discussion on that memo and how you can comply with it, and be prepared to answer those exact same questions during the site visit. Likely, if any of your employees are placed off-site, they're going to be starting to ask you about how is it that you're supervising them off-site, how often do you contact your employee, who's the manager, and are you in touch with the manager, or are you specifically and directly in contact with the worker? Is there a vendor in between, or are you dealing with a direct client, and is it the vendor who's really doing the control? So definitely read through that memo and make sure you're aware of those factors that they're going to look at to determine the employer-employee relationship, because if they determine that you don't have the proper control over your employee when they're at the third-party site, you may find a notice of intent to revoke in the mail for that reason as well. So just a few final points to wrap this up. Our understanding that approximately 40,000 H-1B petitions have been reviewed through this site visit program. It is a very widespread program. As I mentioned, they're trying to cast the net very wide to catch as many of the fraudulent cases as possible. We are also aware, based on those indicators of fraud that were found in that benefit compliance assessment, that there is a worksheet that the USCIS officers fill out when they're adjudicating your H-1B petition, and if certain factors exist, it's likely that the case might be referred for FDNS as well. And again, because of the large number of site visits expected this year, close to 25,000, more likely than not, you will be visited at some point this year. So be prepared for it, and again, be prepared to document how you're controlling and supervising your workers that are placed off-site based on the memorandum that came out previously. So again, my name is Emily Neumann, immigration attorney with Reddy & Neumann PC, located in Houston, Texas. We also have an office in Dallas, Texas. If you have any questions, please feel free to give us a call. You can find us through our website. We are also on LinkedIn, Facebook, and on Twitter.